Production funding for Behind the Headlines is made possible in part by the WKNO Production Fund, the WKNO Endowment Fund, and by viewers like you. Thank you.
Judge Larry Potter on the role of the Environmental Court tonight on Behind the Headlines. I'm Eric Barnes, publisher of the Memphis Daily News. Thanks for joining us. I am joined tonight by Larry Potter, recently retired judge from the Shelby County Environmental Court. Thank you for being here.
It's a pleasure. Thank you for the invitation.
Absolutely. Along with Bill Dries, senior reporter with the Memphis Daily News. Let's start with people who aren't as familiar with what the Environmental Court is. They may actually be more familiar with some of the things you've ruled on and overseen, particularly some of the more high-profile ones. But you, I believe, were the first judge for the Environmental Court some 30 years ago. Is that correct?
Certainly in the city of Memphis, state of Tennessee, I was. I am told by Keep America Beautiful that we were number 3 in the nation. We are considered to be the most active environmental court in the country and the role model for other cities. We have evangelized this concept, taken it to other cities, Nashville, Chattanooga, Knoxville, Jackson, Cleveland, Tennessee, and we go on and on, and many across the country. It is a concept that works, and it is somewhat innovative in its methods.
It is not necessarily what if people hear environmental, they kind of think the natural resources, or they think air quality, water quality. That is a part, but it's a much broader definition of. So go through some of the things that the court handles.
I like to view it as a quality of life court, dealing with more often than not substandard homes, substandard accommodations for people. We deal with blight, we deal with commercial buildings, residential buildings, we deal with vacant properties. Basically anything and everything that's a violation of city code, county code, or state law, we would deal with in that courtroom. Most of the federal issues, though, which are basically the issues that you were related.
Water quality, natural resources, those emissions and so on, pollution in the sense.
We could deal with those, but those more often than not go to federal court because of EPA regulations. We do not deal with EPA issues.
All right, Bill.
Your Honor, you also have a state nuisance law. How much did the state nuisance law, how much did that have a role in changing what environmental court does?
When we initially started that court 35 years ago, it did not have a lot to do with it. As the court grew, then it began to take a much bigger role. And in the last 10 years, we've seen a lot of these cases. The first gang injunction that I dealt with was back, I believe, in 2012. Mm-hmm. And that community was averaging a murder a day when the Attorney General, the city police department came in to us, talked to us about issuing an injunction. I had to do some research on that as to determine whether or not I believe this would be something that could possibly work.
Right, but because in your court, what most people know you for is a building that's in bad condition, and so a gang injunction that works under the nuisance law says, in essence, you have people who we've identified as gang members who cannot congregate in public, who cannot be out after a certain hour unless they're working or doing something like that, and that fell under the public nuisance law.
It did. In that neighborhood we referred to, were averaging a murder a day, mm-hmm. and I signed that first gang injunction in December of that year, and there was not another murder until the following April. So that was very successful. Now, some of the other injunctions have not been as successful, but they still have been successful. And there are a lot of other things we deal with in the public nuisance area, drug dealing, properties that, topless bars that constitute a nuisance in terms of drug dealing, in terms of arrest, other issues that go along with such. And it's been a very active area of the law for us in the last 10 years.
In terms of properties that fall under this, where someone looks at the building and says it's not being kept up, it's not being boarded up properly, how many of those instances are you dealing with someone who just doesn't want to do the right thing? And how many cases are you dealing with where someone just is kind of overwhelmed by the responsibilities of property ownership?
It's a little bit of both, honestly. You asked how many cases we deal with in those two areas. Literally thousands. Several years ago, I helped write a law. We called it the Neighborhood Preservation Act. That was back, I think, maybe in 2006. That law never got out of committee. And then the following year, someone else wrote it, and they were successful. And that, Steve Barlow and I think Dottie Jones and other individuals were very active in that. George Cates and others, community leaders, and that law has become very successful to the point now that we're in the neighborhood of 500 plus lawsuits on that one area of the law itself.
And those lawsuits would be people who, again, it's a blighted home, or it's an abandoned home, or it's a crumbling home? Is that an example?
Under that law, now this is not including some of the legislative changes that are before the legislature now, but as it stands today, it only deals with abandoned or vacant properties, not a property where someone is living in the property. So if someone is living there and it has issues, then that's probably going to be either a housing regulation brought to court, or a Shelby County code enforcement issue, or a health department issue.
When somebody, we've had Steve Barlow you mentioned, who's, I guess, had a lot of hats, but has been very heavily involved in blight and neighborhood preservation, and has been on the show a number of times. He's now involved with Neighborhood Preservation Inc. and the Blight Authority, which came out, I think, the legislation you talked about. When you talk about those 500 cases, you talk about the blighted homes. What is the outcome? It's not about throwing someone in jail or a landlord or a homeowner in jail. I mean, that's not what we're talking about. But we are talking about, the quality of life in neighborhoods, or the threats to value, all the problems that blighted homes bring. What's the outcome? Is it seizing the home?
No, that's not what the court wants to do. What the court wants to do is to go in, if a case is brought and successfully, and it's not easy, but to deal with that case so that it's rehabilitated to the point that it becomes a viable piece of property where somebody moves into that property, it's back on the tax rolls, and we're reducing the blight in the neighborhood. What a lot of people don't understand is that blight and crime go hand in hand. And if you reduce the blight, then you reduce the crime. And that's why we're trying to focus upon the blight within various neighborhoods. And by the way, there are a lot of people that would say, well, this is only in the inner city. No, it's not. This is in East Memphis, this is in Cordova, this is in Frazier. It's all across this county that we have these type of cases. We had a case recently out of Bartlett. Where we had these issues.
Switching, and we can probably come back to blight, but switching, some of the more high-profile cases, I think, that Bill has written about, other people have written about, have been some of the historic properties, I guess, particularly in Midtown and downtown. The consideration, what are the rules from your seat, your rules about, you've got say a I wouldn't go a specific one. We'll just do a hypothetical one, and people can fill in the blanks. You know, a home on a big mansion on, say, Union or East Parkway or something that's been untended for many years. It's crumbling. Someone comes in and wants to buy it. They want to tear it down and turn it into a productive, what they view as a productive small business or restaurant or something like that. You have seen those kinds of challenges where that historic home might be 100 years old, might, you know, some people find it very beautiful, but it is in that sense blighted. So at that point, how are you weighing that the interests of the neighborhood and the historic preservation people and the interests of people who want to come in and invest money and put that property, if not that building, back on the tax rolls?
What a great question. and it's not easy because you've got all of these competing interests and they all want it done a certain way. But what I do in a circumstance like that is follow what the law says. And my goal is to preserve historic buildings. I can give you a couple of examples. The 19th Century Club, Claiborne Temple. These buildings have been in my court. Crosstown, Sears Crosstown, the Goodwin Institute, and the Madison Hotel. On and on, buildings that we have dealt with. What is the goal? To see those buildings preserved, if possible. Preserve those buildings and see them back on the tax rolls, see those properties viable and as a wonderful part of the city. Doesn't always work out. Yeah. Early on, we dealt with a building, I believe it was the old Arcade Hotel, and this is this is way back when, and that building was of such a nature that it was totally unsafe for the public, and I ordered the building to be demolished. And I remember reading an article, and you did not write this, I will say, that said that what I had done, that justice was entirely too swift and that it should have been dealt with differently. 2 days later, the building collapsed. So I mean, these are not easy cases to deal with. We had to block off a part of Madison Avenue.
I was just thinking about that one because the roof had collapsed. This was back, and Wharton was mayor, so 4, 5, 6 years ago. I don't know if it's at the time.
We had to block off
for almost a year.
For almost a year.
Because that building was about a 4-story building, old, kind of architecturally interesting, and ultimately I think that was torn down.
We had to demolish, order it to be demolished because of the fact that it had partially collapsed. And there was such a danger, there was a concern that if it collapsed, there would be a blowout into the street. And if we had citizens walking on that, then someone could be killed. So these are tough decisions.
Staying on historic for a second, I'll go back to Bill. Is it partly, I mean, do you have the tools, or is the law such that if someone comes to you and says, we need to intercede on this building before it gets to that point? I mean, is that the more ideal circumstance, that it comes to you before it's at a point where it's already starting to collapse or it's a danger beyond repair?
Absolutely, and actually, we're in a much better circumstance today than we were 35 years ago, because now you've got experts who will go out and investigate those buildings to see if those structures are safe for the public. And what they're trying to do is to intercede before the buildings get in the condition that we talked about just a few moments ago.
Mm-hmm. Bill?
So let's talk about 100 North Main.
Oh, yes. I wanted to resolve that case before I retired, but I think that was a little bit too much.
Give a little background on 100 North Main, because we may be too close to it.
100 North Main is the tallest building in the city, 37 stories, and as we sit now, it's boarded up better than it had been at one point. Ownership changed just recently. It's at the corner of Main and Adams Street. So you had hoped to resolve it. Now that you're retired, what does it look like the way forward is for this?
when that case came into the courtroom, some of the concerns that I had dealt with public safety. We had debris that was falling from the building. In fact, I went down and did an on-site inspection to view that property to determine exactly what were the conditions, and we had some debris falling when I was there. And so we went back to court and immediately demanded that the sidewalks be caroned off so that no one could walk alongside the building and the possibility of them getting hurt. And then we had individuals that were climbing, getting into the building and climbing to the top and taking photographs that, I mean, you see some of those photographs and it was horrific. My concern was that someone was going to get killed.
Dangerous.
Yes, yeah, extremely dangerous. So then I demanded that we have for the building security, and that seemed to work. The building has been secured. I do believe that there is progress. I think maybe there is a purchaser for the building, and that eventually we will see that building rehabilitated. Now let me say that this is a process. This is the thing most people don't understand, that a building like that is not going to be here one day and the next week it's going to be new, it's in a great state, and people are moving in, and it's beautiful and everything's done. It's a process, and it takes a lot of time, plus it takes a lot of money. And that's something that I've always been a little bit concerned with, because I want it done now. And I've learned the hard way that it's very difficult to get something done now.
Right, and also you have to balance the public need with what are the rights that the property owner has.
Absolutely.
If someone buys a piece of property like that, and their intent, no matter what they say, is to be a speculator, in effect to say, I've got something here that someone's going to want to buy from me. If I just hold on to it, keep it in reasonable condition, or don't keep it in reasonable condition, someone's going to buy this and I'm going to make a profit off of that. We may not like that, but that is that person's right to do that.
Exactly. Now we are beginning to see, though, it's a little bit different than what it was 35 years ago. Now that individual that you mentioned has to do certain things to make sure that building is not deteriorating and is not becoming a problem for the citizens. And we look at it very hard. I demand, or well, I say I demand, I used to demand that the inspectors would go into those buildings, view those buildings on a schedule and report back to the court, so I would know, is this building becoming of a nature that must be dealt with.
And that touched on part of what I was going to ask. When you talk about, you mentioned the site visit, you mentioned all these buildings. I mean, you've got a lot of issues going on, but just simplified as there are engineering questions about the safety of a building and the viability of it structurally and so on. And then there are really kind of financial questions. Is this a viable building at any cost? I mean, is there a viable investor or potential purchaser? You're a lawyer by training. I mean, you're not, and I don't mean this in a bad way, I mean, you're not an engineer, you're not a finance person. So how does that work? I mean, do you have a team? You mentioned inspectors. Do you have people on your staff, excuse me, who go out, or do you employ them? I mean, how do you get that kind of technical expertise on all those factors?
The different agencies for the city of Memphis or for Shelby County will do that. They're not on my staff because they have to be separate from the court, so that the court does not appear to be in any shape, form, or fashion biased. We have to have these reports. We get reports from the individual owners, from their engineers, and then we digest those sort of things. And here's what I've learned in 35 years, that if you have insomnia, a great way to cure that is to read those engineering reports before you go to bed. That will cure insomnia. But I've had to study those reports. I've had to dig into things I never dreamed I would be digging with, honestly.
Yeah. To what degree do you get people who, and I feel myself going into like a 1970s, court drama show where people say, property is 9/10 of the law or something like that, But you must get people coming to court and say, look, this is my property. What I do with it is my business. And who are you to tell me I have to do anything to it? Separate from, okay, it's falling down and it's hitting someone. But, right, I mean, do you get that sort of pushback that this is my property, I'm up to date on taxes, and you've got no right to tell me what to do?
Absolutely. And I loved those cases. Those cases were fun to deal with. Those individuals would come into court and say, what you just said, I'm sorry, I'm not going to do it. Okay. Now, when we started this court back in 1982, we didn't have the jurisdiction to really deal with a person like that. We could assess fines, and that sometimes deterred people, but there were some people that just wouldn't do it. And if you tried to hold someone in contempt as a municipal judge, contempt was a $10 fine. So if you fine somebody $1,500 on a continuing basis, $50 per day plus cost, the $10 fine would certainly get their attention, right? No, it wouldn't.
Yeah.
Now, when we became a General Sessions Court in 1991, then the price to dance went up, and we then had contempt powers that involved 10 days in jail. So,
how many people have you ever jailed for mismanagement of a property?
A lot.
A lot.
A lot.
Now, and you also, I mean, we have just a few minutes left here. For property owners who are because there's certainly health code violations or safety of people, you can imagine those people going to jail.
Yes.
But for an untended property and contempt of your fining, you've put people in jail.
Yes, not because I wanted to do it.
Yeah.
That's the last thing I wanted to do. I gave that individual every opportunity, and I warned him, this is what's going to happen. Yeah. And by golly, it happened.
Bill.
So you took on the environmental court mission. It is your successor, whoever is appointed, whoever wins the special election that's coming up in August, are they obligated to keep the environmental court docket? Could they turn it back to a regular General Sessions court? It doesn't seem likely, but could that?
They certainly could. They certainly could. Now, there would be a lot of people, I think, that would be very unhappy with that because this court has a dramatic impact upon the well-being of our city and our county. And I just don't see that happening. Mm-hmm. I don't. Technically and legally, yes, they could. But I think it would be a mistake. I think it would be a political mistake, first of all. Yeah. When I first ran in 1983, I was told the concept of an environmental court was not something that was politically popular.
Because people heard environmental and they thought this is a tree-hugging court.
Absolutely. Mm-hmm. And we had to overcome that. And we showed people that's not what we're dealing with. And now I think people understand the significance of the court and why it's critical to the well-being of our city, county, and frankly, our state.
The election is when, Bill? Just so people
it's on the August ballot.
August ballot.
Yes.
It was interesting when I was kind of looking at your bio, and we have reported on many, many things you've done. I had never met you until today, but I was struck. I knew technically that you were elected, but it is an interesting concept. So we only have a couple of minutes here, but the idea of elected judges is strange because we put in some, people want to think or hold judges to be as independent as possible, as free of influence as possible. I mean, that's the whole notion behind a judge, that they are nonpartisan, they are free of political influence and so on. And yet you had to run for office, is it every 8 years that you run?
Yeah. Initially,
how do you balance that satisfying the constituents who elected you with you know, as pure independence as you could manage?
Well, gosh, now that you've asked a question that we could talk about for a week,
right.
because we have a minute. In the 1992 election, I ran then so to make sure that judicial elections were independent and that they were not partisan. And that was a very difficult election. We could talk about that for a week. But it is not easy to do. But I do believe that if you do your job, do it right, you're honest about what you do, you're upfront about what you do, that the people will respond to that.
And did you, I mean, were there recusals and times when people were in front of the court that were too close to your campaign? I mean, I'm really not accusing you. I'm just curious how that works with a judge.
Well, it was very difficult. I would always tell the Attorney General or the opposing counsel, I know this person, and if you want me to recuse myself, I will do that.
So the answer was always transparency is to
I've
the degree possible.
always told, I know this person.
Yeah.
I've lost a lot of good friends that way.
Well, unfortunately, we will leave it on that note, but thank you for being here.
It is my honor, my pleasure to finally meet you and to see Bill again. We've been doing this for a long time.
All right. Well, thank you so much, and thank you for joining us. Join us again next week.